This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 92 of This Week in FCPA for the week ending March 2, 2018, the Texas Independence Day edition. In this episode, Jay Rosen and myself take a look at some of the week's top compliance and ethics stories. But first, I'm extraordinarily pleased to announce that this podcast is being sponsored by Affiliated Monitors. Founded in 2004, Affiliated Monitors provides professional, independent integrity monitoring and ethics and compliance assessments nationally and internationally and across almost all industries. With its knowledge of effective ethics and compliance programs and cultures, Affiliated Monitors is respected for its work as the corporate monitor on matters ranging from multinational corporations to small and mid-sized companies and even individuals. Having served in over 600 monitorships, no one has more experience as an independent monitor than the team at Affiliated Monitors. For more information on how an independent monitor can help improve your company's compliance and ethics programs, visit their website, affiliatedmonitors.com. In this episode, we take a look at the continued fallout and discussion from the Supreme Court's decision in Digital Realty Trust versus Soames. 2 corporations received declarations this week, Tetradata and Exterran. We visit Bill Coffin, who continues his string of great blog posts. We explore the derisking issue along the Texas-Mexico border for banks. Fresenius Medical Care announces a €200 million reserve for an FCPA settlement. We have a fascinating discussion on corporate personhood based upon an article by Adam Winkler in the Wall Street Journal. And then we take a look at a couple of data issues. The first is what are the top 5 security and compliance trends to watch in 2018? And then we have a piece from Ben Lockwood, who explains the difference between big and small data. As always, it's a interesting week, and I hope that you will enjoy it. This is Tom Fox. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. Tom Fox, the Compliance Evangelist, back again for another episode of This Week in FCPA, episode 92 for the week ending March 2, 2018, the Texas Independence Day edition. As always, I'm joined by Mr. Monitors, Jay Rosen. Jay is speaking to us today from where it's always sunny, San Diego. He's just concluded his attendance at the ABA White Collar Conference, so he's going to give us a report on that. And Jay, I suppose it's even sunnier in San Diego than regular Southern California.
Yeah, and the big thing here is I guess there's a huge storm brewing on the East Coast, a big nor'easter. So a lot of folks from Boston and New York tried to get out last night, but there's a lot of flights being canceled and people are having to hang out. And I've got a beautiful view of San Diego Harbor. So there's worse places in America to have to lay over.
Okay, well, Jay, we had a pretty interesting week, so why don't we just jump right into it? I just wanted to note that the commentary and indeed fallout and discussion from the Supreme Court decision last week in Digital Realty Trust versus Soames continues. I took a deep dive into it, both from the legal perspective and some of the issues from the compliance perspective. But then I also had the chance, Jay, to podcast with Roy Snell, still president of the SCCE, and then with Matt Kelly. And for our listeners who would like to really take a deep dive into what the implications of this case would be, I would really suggest they check out those 2 podcasts. The one with Roy is the FCPA Compliance Report, episode 372. The one with Matt is Compliance Into the Weeds, episode 72. And it really gives a sense of many of the unanswered questions that we have, both for the compliance practitioner, the compliance profession, corporate compliance programs, and even the SEC. So Roy, as always, is very insightful, coming at it from a 30-plus year compliance professional and chief compliance officer perspective. Matt really took a look at it, I thought, from more of a ERM regulatory perspective. But when you put those together and consider some of the points that I raised in my 2 blog posts, I think there's really a lot to digest. I'm going to have a further podcast on this. I'm going to talk to Stephen Durham, a lawyer who has an extensive whistleblower practice at Labason Sutro, and get his perspective, and that'll go up in the next week or two. But it really continues to resonate. I was on a panel at the University of Texas yesterday, Longhorns and Compliance, and this case came up for discussion, and the panelists were chief compliance officers who were talking about the responses that they had put in place already to try to keep employees to whistleblow in-house first. So I think this one's going to be here with us for some time, and there's lots to digest. If you're a compliance practitioner or chief compliance officer or other, I would really suggest you check out those podcasts, because it may give you not only some of ideas of the issues you may face, but also both Roy and Matt and I talked about some of the solutions you can put in place now to help ameliorate some of the effects of the Supreme Court case.
So a couple things. I actually got to spend some time with Steve Durham in person here as well.
Oh, great.
So lovely guy, and I'm sure he will provide a great perspective on this because of his whistleblower's practice. At the end of your second blog, it looks like from maybe today, March 2nd? I don't know. It says, sometimes getting something you think you want is much worse for you than not getting it all. So if you can maybe just kind of clarify quickly, who exactly was pushing for this? And now, how did it get up to the Supreme Court? And then how are people, now the reaction is there that it's really going to hurt the corporation. So what was the genesis of all this?
So there were 3 separate cases where individuals filed whistleblower lawsuits claiming Dodd-Frank protection, and those percolated up. They're filed in federal court because it's based on a federal law. One was filed in the Fifth Circuit Court of the Fifth Circuit District here in the South, which includes Texas. One was filed in the Second Circuit, your old neck of the woods in Massachusetts and New England. And then we had the case that went to the Supreme Court, Digital Realty Trust, which was from California, filed in the Ninth Circuit. And in each of those cases, the claimants or the complainants in federal court, plaintiffs, filed actions claiming they were terminated illegally under Dodd-Frank because they claimed whistleblower status. In each of those 3 cases I mentioned, the plaintiffs blew the whistle internally or reported internally first, and they were alleged that they were fired for their efforts and filed suit. The companies defended on the basis that Dodd-Frank did not allow or protect, rather, whistleblowers who complained or reported internally initially or reported internally only, I should say. So that was the basis of the lawsuits, and that was how we got to the 3 cases. And what happened, Jay, was, and why the Supreme Court took it was, there was a split in the circuits. The Fifth Circuit in Asada said employees who don't whistleblow to the Securities and Exchange Commission do not have whistleblower protection. I forget the name of the plaintiff in the Second Circuit case, but they ruled an opposite, saying that deferring to the Securities and Exchange Commission, who had interpreted Dodd-Frank to allow either whistleblowing to the Securities and Exchange Commission directly or internally, and then the Digital Realty Trust, which also followed the Second Circuit. So there was a split between the Second, Ninth, and Fifth Circuit, and that's why the Supreme Court probably took the case. The group that came up with this theory, of course, was the Corporate Legal Department. And here I would invite you to consider the difference between and function of a corporate legal department and a compliance department. A corporate legal department is charged with defending the corporation, and when a lawsuit's filed against a corporation, generally a legal department and their outside counsel will avail themselves of all legal rights that they would have to defend the lawsuit. And here they argued successfully in front of the U.S. Supreme Court that Dodd-Frank whistleblower protection only came for people who filed directly with the commission. So that's really how that decision got made, whether that was in consultation with the compliance to functions of those corporations obviously is not known at this point. I would note, Jay, that GE, who was the defendant in the Asada case, had actually argued to the SEC when it was crafting its rulemaking that the employee should have to self-disclose internally first. So that was the position GE took during the real rulemaking process. And when GE took the opposite position in court when the Asada lawsuit was filed. So you have corporate legal departments making claims or providing defenses to lawsuits, which is their obligation. But in many ways, these same arguments probably turned around and shot the companies in the foot by now forcing employees who want legal protection to go to the Securities and Exchange Commission and not report internally. So it really is a big situation of don't ask for something, you just might get it.
Can we say FUBAR?
We can certainly say FUBAR.
Okay, so it's it's going to be interesting because it now could just create a lot of extra work for the SEC, and to your point earlier, now the company's not going to enjoy the protection of learning about things first, and if they have to wait. You've got a whistleblower internally who's gone to the SEC. Now the company is definitely at a disadvantage to start remediation, and then might open up a whole can of worms if they end up taking some type of termination action and not knowing that this is a whistleblower.
So Jay, we had 2 declinations announced this week. You want to tell us about those?
Yep. So first one we have is Tetradata Corporation, and they announced in an SEC filing that the FCPA investigation into gifts and travel expenses at a subsidiary in Turkey has ended, and the company won't face enforcement. And, it's a standard kind of language that came out in the Form 10-K. And on January 16th of this year, the SEC advised that its staff will not recommend any enforcement action. And on February 20th, 2018, the DOJ also advised the company that will not take any enforcement action and that its investigation into the matter is closed. The next one that we have is this is from Richard Casson, at our good friend in our publication where you write sometimes, Feds and FCPA probe of oil and gas services firm. This is something that's right in your backyard. Houston-based Exterran said that their 2-year investigation had focused on equipment contracts for desalination plants in the Middle East. The company first disclosed the potential problem in April of 2006, and in Wednesday's filing, it said the SEC staff has notified the company that they have concluded their investigation concerning compliance with the FCPA. This is now the 5th company to report declination in 2018. So it seems like we're getting off to a good start in terms of declinations, but I'm sure there will be something new coming down the road.
So let me just throw in a big shout out to my good friend Rod Hardy. Rod is the Chief Compliance Officer at Exterran. Rod and I are both recovering trial lawyers, have known each other for many years here in Houston. When I went to Halliburton, Rod went to Baker Hughes, and then worked under Jay Martin, and later became the Chief Compliance Officer at Exterran, and has took Exterran through this FCPA investigation with a declination received. So congratulations, Rod. Good job.
So with the just concluded Olympics, our good friend Bill Coffin at Compliance Week has something that deals with one of your favorite sports, the sport of curling. So why don't you take it from there, Tom?
Sure. So first of all, a huge shout out to Bill Coffin, not simply because he's my boss at Compliance Week, but because this is the 4th home run in 4 weeks he's hit on his blog, his weekly blog, Coffin on Compliance. So congratulations, Bill. Keep it up. But what he does, Jay, is he uses the curling, the Russian athlete, not curling under the Russian flag, but Russian athlete nevertheless, who was caught using performance-enhancing drugs as a way as an entree into the subject of what do you do when you're already a one-time loser under the FCPA and you have a recidivist event. So say you've got a DPA or an NPA or even a declination, and then it turns out that there is another problem. So in my last corporate position, I worked for a company that that situation had occurred, and I can only assure you that as negatively as the DOJ and SEC might think about your initial compliance failure, if you have another one, they will have an even more dim view. So, but what Bill does, Jay, is take this fact scenario of the Russian curler who used performance-enhancing drugs in the context of Russia trying to be allowed to come back in to the bosom of the Olympic family for the next Olympic Games, and really raises the question of what do you do if you're under a DPA to prevent new information or another event from happening? And he gives three different things that can help them manage the risk. And I thought these were pretty creative. The first one was, and it's one that's talked a little bit, but really not enough, I think, which is amnesty. And he says when facing the aftermath of a compliance failure, it's crucial to root out any other problems. And to do so, he suggests offering an amnesty program to all employees to report any other activities which may potentially violate internal or external compliance protocols. This was used successfully by Siemens and their record-setting FCPA enforcement action. And it's something that, if appropriate, is something you should consider. Obviously, honesty is important, that any wrongdoing detected simply has to be self-reported to the appropriate authorities. If something happens, you got to tell the regulators. And finally is transparency. And going forward, he suggests that all policies and procedures have to be crystal clear for both a wide variety of stakeholders. That can be your employees, internal practitioners, but also for outside observers and monitors. There has to be a 100% certainty that your operations are within bounds and that there is nothing to hide. So a really good job by Bill Coffin. And if you find yourself under a DPA, NPA, or even received a declination, you want to make sure that you don't have to go back and self-disclose something else to or worse yet, have the Department of Justice find out about something else. So some good advice there.
Next, we're
going to go down to the Texas-Mexico border and some banking issues. What do you have for us, Jay?
Yeah, so we've got a couple things. We've got an article from Sam Rubenfeld in the Wall Street Journal, and then we also have an article that we're going to link to in the show notes from Matt Kelly. And what seems to be happening is that there's a situation where the banks are being de-risked, and they are kind of refusing to do business with a lot of cash-based businesses and customers who are on the border. And part of it seems to be a little bit confusion among the laws for what should be done from an AML risk perspective and how they're dealing with actually putting this into function and servicing their clients. So is this something new, Tom, that's been happening along the border that you've been aware of, or is this in reaction just to the new statutes?
No, I think it's been going on for some time, but it's really around two things. I think increased enforcement of anti-money laundering laws, particularly for Mexico and places south, but also U.S. banks now becoming more aware of their obligations and their risks. I think we saw the situation in Miami several years ago because there was a greater focus on Miami. And as those banks wised up and got better AML programs, the nefarious actors shifted to the more fertile area because there was less concern and less compliance, which was on the Texas-Mexico border. So this was really the first time there had been a significant report considering these issues. The GAO, Government Accountability Office, said that originally opined that these types of transactions created challenges for banks, really implying that simply because of AML regulations, it was causing banks to lose customers and perhaps revenue. Matt Kelly took a look at it in terms of de-risking risk and really looked at it, as always, as Matt does, from the ERM perspective. And I thought his take on it was, look, guys, this is a risk. You've got an AML program, and you've got people who can't show you that they've got clean money. That's a risk for you. And if you want to take that risk, you can, but obviously the sanctions can be quite high. So it's really just a risk issue, not a regulation issue. And if we're going to have any type of substantive AML programs for banks literally anywhere in the United States, it's going to have to apply in the areas where the most potential dirty money is coming. So I guess it really didn't surprise me too much.
Right. So next up, Fresenius Medical Care, which is a German dialysis company, has reserved 200 million euros in its FCPA enforcement action. And what did Jacqueline Jaeger have to say about that?
Well, really not much more than that, Jay, because the information she got and other commentators or reporters had was from their latest 8K filing. So 200 million euros, about $280 million, I think, at this point, maybe a little bit more. So it's a fair chunk of change, and we'll have to wait until, if and when, I should say, the matter's resolved so we can get the actual claims or underlying facts of the violation. But always good to see when something like this is reported, because it generally means there's a resolution sooner rather than later.
Mm-hmm. So next up, we've got a really interesting article that you found in the Wall Street Journal, and it's an idea and essay by Adam Winkler. And he asked the questions about what rights should corporations have. And he just really takes a very interesting look going back into the 18th century and how corporations were given rights and being able to act almost as a person. But what's bringing this up now specifically are some of these controversies about whether or not, a baker in Colorado can sell a wedding cake to a same-sex couple, or whether or not a company has a right to deny birth control to employees because it's violating their religious liberties. So how did you find the article, Tom, and what are your takeaways from it?
So it was a great review, Jay, of how corporate rights were originally brought into the legal system. The first case was in 1809 in front of the U.S. Supreme Court, and how really corporations have led in many ways, the legal discussion around various rights granted to them under the Constitution and by various laws. I would point out that a series of cases in the 1870s called the slaughterhouse cases presaged the revolution in the 14th Amendment law, which occurred in the 1930s and 40s in the United States. The same claims were made in the slaughterhouse cases, but that court said that the 14th Amendment did not apply to corporations. Later, Supreme Court rulings said that due process did apply to corporations under equal protection of the laws because corporations were persons. So there's a rich history of this. Because corporations have money, they can get to court more often and pay to litigate issues that are important to them. So it's probably, if you think about it, not really too surprising that a fair number of corporate cases have gone to the Supreme Court. And we have to take a little stop here, Jay, because I have to announce that Michigan State has defeated Wisconsin in the Big Ten tournament. Thank you very much. Go State. But there are some commentators now who want to amend the Constitution to eliminate some rights for corporations that individuals have. There are certainly downsides to that, and I think it's an interesting question. Are we moving to corporate personhood? That's a great topic of many science fiction thrillers that I've read. But this article by Adam Winkler took a look really from the legal perspective. Obviously, we've linked to it in the show notes, and I would commend this to everyone to read because it gives a different and fresh perspective on something that, although is very important in American life, I don't think we really focus on quite as much.
So next up, we've got a couple articles that deal with technology. One of them is Anthony West exploring in corporate compliance and insight. He's going to look at the top 5 security and compliance trends. And then you've kind of followed that up with an article that you've chosen about what is the difference between big data and small data. And Ben Loughlin explains that in Pharmaceutical Online. So what's your interest in those stories, Tom?
So Adam West in an article.
Adam West was Batman. Holy smokes, Robin.
Holy smokes. He wrote an interesting piece in Corporate Compliance Insights where he talked about 5 trends to watch in security and compliance. And those trends, I'll just go through them quickly. Companies need to ensure that they are using the latest technology to protect themselves from internal and external threats. With regulations like GDPR on the top of mind, trusted immutable data, meaning data you can't change, and open access to data repositories will play a central role in compliance efforts going forward. The explosion, number 3, the explosion in the volume of data will continue to grow exponentially, requiring firms to leverage new tools internally and externally to improve employee productivity. Something I've written about quite a bit is AI will continue to evolve in the business conversations, allowing corporations to increasingly increase workloads that are available for review. And finally, blockchain ledgers will become more widespread. So these are trends that I think we all need to follow. These are certainly things I'm going to be talking about in my new podcast series, Innovation and Compliance. And that's what really led to the next article by Ben Loughlin. Ben's from your part of the world, Jay, or at least your former part of the world. He is a data scientist. He's a PhD. He's a double PhD in healthcare, biology, and I think data science, and a really smart guy. And he wrote this very interesting article about both big data and small data. And this, actually, I thought of you guys, or affiliated monitors, I should say, when I read this, Jay, because Ben talked about the uses and misuses of big data. But his point was that really big data alone is about finding correlations, and small data is about finding causations. And he particularly noted that with small data, the way to obtain it and then analyze it is something that Affiliated Monitors does when it's assessing corporate culture. So he said, in small data, meaningful insights are often derived from anecdotes, focus groups, and other modalities that draw inferences from impossibly small data sets. And it seems to me that those are many of the techniques that Affiliated Monitors uses when assessing corporate culture. So it's, as always, everything Ben writes, it's a great article. I've cited him extensively in my blog posts over the years, and he's somebody you should definitely keep your eye on from the compliance perspective. So a couple of pieces of data for us. And then, Jay, we ended up with an article by Joe Mont at Compliance Week, my colleague at Compliance Week, where he talked about there's some legislation at the federal level to end secrecy in workplace harassment settlements. You want to tell us about that?
Sure. So the act is called the Sunlight in the Workplace Harassment Act, and it's been sponsored by Senators Elizabeth Warren, Democrat of Massachusetts, and Representative Jackie Rosen, no relation, Democrat, Nevada. And basically, the flood of allegations of sexual misconduct against powerful individuals has created a moral imperative for all of us to shine a spotlight on the abuses of power in the workplace, Rosen said. The Sunset in the Workplace Act would require public companies to disclose the total number and aggregate dollar amount of disputes settled by the company related to sexual abuse or harassment. It would require public companies to disclose the average length of time it takes to resolve these complaints. It would prohibit the SEC from disclosing names of accusers and provide accusers with the option of limiting the extent to which details of the settlement are disclosed. And finally, it would require public companies to disclose information on their efforts to prevent the perpetration of harassment, discrimination, and abuse by their employees. And it seems to be a pretty widely supported measure. Senators Edward Markey, Democrat from Massachusetts, Jeff Merkley from Oregon, California's own Dianne Feinstein, Richard Blumenthal from Connecticut. So it is seems to be coming from all states. These are all Democrats, though. So it sounds like there might be a little bit of a politicization on this, but I think this is a timely act, and especially with the Oscars coming up on Sunday, I'm sure there's going to be some type of reaction from Hollywood from the Me Too, and I think this act kind of stems from what's happened and been brought to light over the past 6 months.
So, Jay, as I noted at the start of our podcast today, you're down in San Diego for the ABA White Collar Conference. I was wondering if you might have a few thoughts for us and any particular highlights.
Sure. So this conference started off on Tuesday night with a cocktail reception. And as I was telling you before we got in the air, Tom, this is really an opportunity for people who are practitioners in the white collar bar to get together, renew relationships, and to see old friends. And about 30 years ago, this was started by Ray Benoon, and I think there was something like 5 people in a conference room. It's grown to over 12,000 people, and they've got a lot of great folks here who are either former AUSAs or people who are now in the government, who are or have moved to private practice. Some of the events that they discussed is there was a very interesting panel I attended from state AG enforcement trends, and these were former attorneys who are now in private practice, but they worked either in the Central District of California or somebody else also worked in New York City. So we had an opportunity to compare and contrast the differences between what's happening within the government and then how you handle that when you are working in private practice. We heard from enforcement updates at the SEC from Stephanie Avakian, I think you say, and Stephen Pakin. And they really said it's business as usual at the SEC. One thing was kind of interesting is that they're with the new FCPA corporate compliance program, there is that presumption of a declination. And the issue that they brought up is they've got a declination with disgorgement, and that's with DOJ. And unfortunately, that will usually open the door up to some type of SEC action because the SEC does not have a similar perspective with, starting off with a declination. So they said they do not see any change in that they're going to do that. And the reason the SEC there is to deal with issuers. And if you've made a mistake and you've come forward, that's part of the price you need to pay. There was an FCPA panel chaired by Bob Taroon from Baker McKenzie, and they had Dan Kahn was there and also Charles Kane. So I would say, the fun thing today was hearing the Deputy Attorney General, Rod Rosenstein, speak. And as always, he's very eloquent, quotes a lot of history. One of the things he said is that there are portraits of people that he walks by when he is in the building. And he has served under, I believe, 8 different attorney generals. So there are Republicans and there are Democrats. And the pictures that he walks by are the pictures of 3 people who served during a very tumultuous times in the Department of Justice. And I'm looking for my notes who those 3 people are. They were Attorney Generals Jackson, Levy, and Ashcroft, and the controversies that were part of their jobs were post-World War II, the Watergate scandal, and 9/11. And the DAG just thinks about, there is a duty to serve and to uphold the rule of law. And he was very eloquent, especially in light of all the the animus that is coming from the executive branch and the president, directed not only Sessions but also at Rosenstein. It was a very supportive crowd. It was good to have him take the time to come out from Washington to address us. And I think it put a nice cap on the event. And we are looking forward to next year already. It will be in New Orleans the day after Mardi Gras. So I think it could be a little bit of a crazy time there. And then they will be back in San Diego in 2020. And then they're thinking about going to the Bay Area and San Francisco. So from Affiliated Monitors, we had Eric Feldman and Don Stern, and then we had a couple of our colleagues from across the pond, Jason Sugarman and Mark Ransford, and they're part of our affiliate RSL Legal Strategy. So a great time was had by all, and if anybody watched me on LinkedIn, I'm getting ready to take the train back to Los Angeles and stretch out with extra leg room, plug in, and start answering emails. So that's my plan for the afternoon.
Well, very cool, Jay. I need to reiterate my next book, The Complete Compliance Handbook, is now available for pre-sale. It's going to be published in April 2018 by Compliance Week. You can check it out on my website, www.FCPA-compliancereport.com. And for those wondering why we're celebrating Texas Independence Day today, it is because on this day in 1836, the Texas Declaration of Independence was proclaimed, and Texas proclaimed itself a republic from Mexico. So next week, Jay, we're going to celebrate, or at least remember, the Alamo in a post I have every year based upon some thoughts Chuck DeRoss gave that I find are still relevant. So we're going to be thinking about Texas independence and the Alamo for the next few days. You want to take us home?
Sure. So on behalf of Tom Fox, the compliance evangelist, and myself, Jay Rosen, Mr. Monitor, we'd like to thank you for spending some time with us, taking a look at the week that was in FCPA. This has been episode number 92 for the week ending March 2nd, 2018, the Texas Independence Day edition.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of This Week in FCPA. If you have listened to this podcast on iTunes, I greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the only weekly roundup of all things compliance and ethics. If you have any questions, you can email me at tfox@tfoxlaw.com. You can email Jay at jrosen@affiliatedmonitors.com. I hope you will check out my new book, which will be out in next month, The Complete Compliance Handbook. You can take a look at it at my website, FCPA-compliancereport.com. And once again, I'd like to thank Affiliated Monitors for sponsoring this podcast. This Week in FCPA is a part of the Compliance Podcast Network.